A regional court in Tanzania this week ruled on the long-standing land dispute between the people of the Maasai and the Tanzanian government. The court dismissed the case with costs to both parties, stating that the Maasai could not prove beyond a reasonable doubt that they had rights to the land, that they were actually being evicted from free-owned land or the Serengeti National Park. The people plan to appeal the ruling. Now, for more on this, we speak to one of the lawyers who've been working closely on the case and a lawyer from the Legal and Human Rights Center in Tanzania, Advocate Joseph Ole Shagay. Advocate, thank you so much for your time and thank you for joining us this morning. Very quickly, your reaction to the court's ruling.
Okay, thank you very much for having me this morning. Our quick reactions on the case, and actually to put it into perspective, the Friday court judgment was not related to June operations by the government. It's a different thing. It was back in 2017. Now the court has pronounced itself. It has said that we have failed to prove that the Maasai were evicted from the village lands. The court, however, says there was evictions, and the government agrees to that fact. And again, the court again agrees that all that land adjoining Serengeti National Park is a village land. And to put it into clarity, that is the land where the operation was taken in June. What the court has said we have not proved to satisfaction of the court is whether the eviction took place within Serengeti, as the government says, or within the village lands. And we think, it is our opinions, and we are appealing for that fact. We think the court, for some reason, misapprehended nature of evidence. We had an expert, geospatial expert. He has established that the burning of bombers took place within village land outside Serengeti National Park. The court discredited his report, not because of is not matching with facts or anything related to that, because he's a Kenyan national. Because the court says he had no work permit, and we think that was beyond the power the court has. You cannot control as to who we can employ for the task and things related to that. So the court now is saying we have failed because the experts who were brought in was a Kenyan nationals and says had no working permits in Tanzania. The Tanzanian law do not say that. The East African law does not require that fact. So we think the court has actually overstepped some of its mandates.
Right. And we'll circle back to your perception of the court's overstepping with regards to this particular case, but I am curious about what message you think this sends out. Either way, we're talking about the forced removal of people from their homes, as was witnessed in 2017. I mean, that's quite egregious, and for the court to essentially stand by that, what message do you think that sends out?
Of course, it has already sent a very bad signal to many people, because now the government is using the court order for Friday to justify its operation in June. Despite the fact, actually, if you are to read the court judgments, it says the land outside Serengeti National Park is a village land. Now the government is saying these people has complained in 2017 and again are complaining now. The nature operation in 2017 is the same as the one in June. And the court has said that operation was undertaken with dignity, with observers of human rights of 2017. And just for the records, we submitted to the courts more than 300 bombers were burned to ashes. And the court says that with dignity. And I think we do not agree with that. But again, it has another thing is, the judgment was to be delivered on June. We think, is our opinion, the scheduling for 3 months only to come with these judgments to us is another message that maybe some reform are needed not only in the local courts but also on the regional courts. because the rescheduling actually happens when there was violence in Loliondo, which otherwise the court allowed the government a leeway to ensure that that operation took place indefinitely until it has become successful. Of course, we have filed another case differently by the end of August, so mid-August actually, related to the June operations. We are filing an appeal to the same court, the appellate divisions, to see whether the court was right. First, because if you're to do the judgment, there is not any analysis as to how the court reached to that finality. It is just mentioned how the witness says, and they have said operation took place within the village land, not Serengeti. Of course, the government's officials said in Serengeti. There is no analysis discrediting witness. It is just come in the ruling that the witness were not credible and things related to that. But the court does not show how did it end to that conclusions. Where did it drew the facts to that finality?
Right.
Yeah.
Well, you have questioned whether or not the court has acted within the confines of the law. You've mentioned that as an organization, you believe that the court, the East African Court of Justice, in fact, overstepped when it comes to its ruling. Now you're also questioning the legal analysis, the judicial analysis, rather, that took place in the lead-up to the ruling being handed down. I mean, what confidence do you have at this point in the judicial system to actually come to a conclusion that is satisfactory for yourself and, of course, the Tanzanian government?
One thing is, when you are going to court, does not necessarily that you must win that case. And we are not complaining because we have lost. It's the circumstance to which the judgment was delivered. But now, as lawyers, reading to the contents of the judgment, you can spot. There were previous 3 or so rulings by the same courts on the same subjects in 2017 and others. And back in 2018 actually, not 17, in 2018 the court has said the government is using extrajudicial mechanism to force the Maasai to pull out the case. It also says the government is using the police to ensure that it distract the Maasai from continuing with the case. And again, it orders the government not to interfere with the operations. The government interfered with the court order. We filed a contempt of court application. It has never had, and the court did not even mention it. And even if you look on the temporary orders court issued back in 2017, compared to the now rulings, you can easily spot there were better analysis on those temporary orders, far away better than the judgment delivered. It's like this judgment was prepared in hurry, while the court actually had more than 90 days to prepare. It's not just like we have lost. How the court analyzed the law, analyzed the case law, analyzed the facts, I can admit there is no any sort of analysis.
I want to get to the heart of the issue, Advocate, and that being, of course, issues around environmental conservation. The Tanzanian government has argued that largely the reason behind the removal of the Maasai community is conservation. It is conservation-based, essentially. What's your response to that? Because I know that previously in our conversations, you have argued that really the motivation for the government's acts in all of this is monetary-based.
Okay. And just to put it again better, is what the government is saying they're evicting the Maasai for conservation purpose. But when now they were in court, they never said that. They said, we evicted them within Serengeti National Park. And the Maasai are saying, we have never been in Serengeti. We know where the border is. We know where the beacons are. We have never crossed the beacons. But in fact, where the operation was taking place was within the village land, the 1,500 square kilometers, where the government wants it for hunting. They cannot explain to that court, so they say it's within Serengeti National Park. Better is, the court has said, okay, then all that land outside Serengeti is the village land. And now the government has gazetted it already, that land where the court has said is a village land, and the government agrees, it has gazetted as a game control. So coming to your question, we have said it repeatedly and we say it now. The purpose behind is not conservation. Maasai has never been a threat to conservation. Pastoralism has been proved beyond normal thinking. How is it compatible to nature? Where the government is now trying to squeeze people out of the areas is places where the pastoral people are, because the only place they can find wildlife. But again, this government says is conservation. But at the same time, they are removing them to allow some people to kill the wildlife. That is not conservation. Is another bad business, but can be explained in conservation lens, because everyone likes conservation. They think it's the good things, it's about nature, it's about green and things like that. But that's not the purpose. The purpose is there are multi-billionaires, billionaires, who want to invest in luxurious hunting, lodging, and that's the crime the Maasai has committed, is living in wildlife-rich areas.
Advocate, sorry to interrupt you, because we are running out of time, and I know that you've already mentioned that you are going to be appealing the case based on your dissatisfaction with the ruling. But I wonder if you have any interest at all in furthering your legal interests at the African Court on Human and People's Rights, given the fact that the East African Court of Justice has delivered the verdict that it has.
Okay. There are legal issues there. Actually, the African courts has a wide jurisprudence on these issues like indigenous land rights and things related to that. The bad part of it is the Tanzanian government withdrew the mandate of individuals and the CSOs to file application to the court back in Magufuli regimes. Samia government has not removed that clause. That reservations. So it's very difficult to go to that route unless you go to a long route to Gambia, the African Commissions, where you must again exhaust the local remedy, going through the local courts. And again, those regional tribunals or courts do not really receive case that has been adjudicated through the regional court. So the East African is a regional court, so you cannot again, like, that will be a sort of a window shopping, which in law is really not allowed. There are different cases. I think there are others we can explore. We have already the cases in the Tanzanian courts. Maybe we can end up in through the commissions to the African courts. It will be a very long way to go, but we will definitely.
All right, that was lawyer from the Legal and Human Rights Center in Tanzania, Advocate Joseph Ole Shagay, talking to us there about that regional court not ruling in favor of the Maasai community when it comes to those forced removals that took place back in 2017.